Today is Monday, June 8th, 2026, and we are unpacking a breaking federal court ruling out of Boston that just struck down a highly controversial change to how highly skilled workers enter the country.
Yeah, the case really centers on an attempt to take a standard, administrative fee and multiply it by up to 50 times.
50 times.
Yeah, transforming it into something the courts had to, carefully define.
Okay, let's unpack this. Our material today comes from legal filings and news excerpts detailing the judicial overturn of this newly imposed H-1B visa fee.
And we should probably mention the context here, right?
Yes, definitely. Because we are looking at an executive action originally enacted by Donald Trump, a lawsuit filed by 20 Democratic state attorneys general, and a ruling handed down by an Obama-appointed judge. So the politics here are, incredibly loud.
Oh, absolutely deafening.
But our mission today is to mute the politics.
Okay.
I want to be super clear with you, the listener. We are not taking sides here. We are going to look strictly at the constitutional mechanics, the economic reality of pricing out an entire industry, and the very fine, incredibly consequential legal distinction between a penalty and an unlawful tax.
Right, because those constitutional mechanics, they're what ultimately decide the boundaries of presidential power.
Exactly.
In the courtroom, it's the text of the Constitution and the operational reality of a policy that carry the weight, regardless of the political environment surrounding the whole case.
So we really need to start by looking at that operational reality, the sheer scale of the change that triggered this whole legal showdown.
Yeah, because this isn't a story about a processing fee going up by 10% to keep pace with inflation.
No, not at all. To understand the shockwaves this caused, we have to establish the baseline of the H-1B program. What exactly is the function of this specific visa?
So the H-1B program is a targeted pathway. It's designed to allow U.S. employers to temporarily hire foreign workers in specialty occupations.
So we're talking about highly skilled individuals, right?
Right. Software engineers, medical professionals, research scientists, financial analysts, folks like that.
And it's not unlimited, is it?
No, not at all. Congress capped the program, so it currently offers 65,000 standard visas annually.
Okay, 65,000.
Yeah, plus a carve-out of an additional 20,000 visas specifically reserved for workers holding advanced degrees.
And these are temporary authorizations generally approved for, a window of 3 to 6 years?
Usually 3 to 6 years, exactly.
And for decades, this has been a massive pipeline for American companies. The tech sector, major hospital networks, universities, they all rely heavily on this program to recruit global talent when they can demonstrate a shortage of those specific skills domestically.
And securing that talent involves a recognized cost of doing business.
Yeah.
Historically, employers seeking an H-1B visa paid a processing fee to U.S. Citizenship and Immigration Services.
Right, the administrative overhead.
Exactly. Before the September proclamation, the center of this lawsuit, that fee typically ranged from about $2,000 to $5,000.
Okay, so a few $1,000s.
Yeah, and it's scaled based on the size of the sponsoring company and whether they required expedited processing, things like that.
So that fee covers the administrative plumbing, right? The background checks, the paperwork processing, the bureaucratic overhead.
Exactly.
But then the September proclamation drops, and the administration announces a new fee structure for these new H-1B visas. They set the cost at $100,000.
Yeah, it's a huge jump. They took the absolute ceiling of the standard fee and multiplied it by 20.
Or if you're looking at the floor of $2,000, they multiplied it by 50.
By 50, exactly.
Which brings us back to that toll booth analogy. When a cost jumps from a predictable $5,000 to a staggering $100,000 per applicant, the immediate economic consequence is, an absolute paralysis of the system.
Total gridlock.
Right. And we saw this documented in a March court filing from the administration itself. By February 15th, U.S. Citizenship and Immigration Services had received a grand total of 85 payments.
Just 85.
85. Out of a program structured to handle up to 85,000 visas a year, they processed 85. How does an entire federal apparatus built to process tens of thousands of specialized workers handle a drop to functional zero?
Well, the short answer is the apparatus doesn't process them, because the drop to functional zero was the intended consequence of the policy.
Yeah, really? It wasn't just a byproduct?
No, this wasn't an administrative glitch or a failure of the system to process applications. From an economic perspective, this was an intentional deployment of market forces.
Wow.
Yeah. When a regulatory body raises the barrier to entry to a, mathematically prohibitive level, they are relying on basic economics to execute the restriction for them.
So the 20 Democratic state attorneys general who brought this lawsuit, they built their entire case around that specific economic fallout.
Yes, they did.
Yeah.
They documented what legal scholars refer to as a chilling effect.
A chilling effect. I've heard that term.
Yeah, the chilling effect is a really critical concept in administrative law. The state submitted all this evidence, affidavits from tech startups needing specialized coders, rural hospital systems desperate for specialized physicians, universities recruiting researchers.
All these places relying on that pipeline.
Right, demonstrating that these entities were suddenly and entirely priced out of the international talent market.
I mean, paying $100 grand just to apply.
Exactly. The 85 applications represent the handful of ultra-resourced corporations that could actually afford the exorbitant toll. For the rest of the broader economy, the consequence was a hard, immediate halt to global recruiting for these vital roles.
But hitting zero applications isn't just an economic anomaly, it's a massive legal liability, isn't it? When you price an entire sector out of a federal program, you practically guarantee a lawsuit.
Well, without a doubt.
Which naturally leads us to the question of how the executive branch justified imposing such a prohibitive cost in the first place. I mean, the administration did not walk into federal court and argue that the price of printer paper had skyrocketed, right? Making it cost $100,000 to process a single application.
No, they didn't even try that.
Yeah.
They abandoned the concept of a processing fee entirely.
So what do they call it?
What's fascinating here is that the administration's legal defense took a completely different avenue. They argued that the $100,000 charge constituted a monetary penalty.
A penalty? Wait, I'm genuinely stuck on this legal logic. If the Constitution is so clear about the separation of powers, how did the administration's lawyers attempt to justify this in court?
It's a very creative argument.
But if it's a penalty, what exactly are these employers being penalized for? Applying for a visa through a legally established congressional program.
That's the crux of it.
That feels like receiving a massive $10,000 speeding ticket when you haven't even started your car yet. You're just sitting in your driveway holding a valid driver's license. How does a legal application process trigger a penalty?
So the administration's lawyers pointed to the executive branch's broad statutory authority over immigration enforcement.
Okay.
Specifically, federal law grants the president the power to suspend or restrict the entry of foreign nationals if their arrival is deemed, detrimental to U.S. interests.
Right, we've seen that power used before.
Exactly. So the legal theory they tested in court was that because the president has the authority to restrict entry, the act of an employer seeking that entry, contrary to the administration's broader policy goals of protecting the domestic labor market, could be penalized financially.
Oh, wow. So they attempted to merge the concept of a regulatory barrier with a punitive fine.
Yes, they were actively trying to weaponize the fee structure.
Instead of outright suspending the H-1B program, they just created a financial moat so wide that nobody could cross it.
Exactly. Because a direct suspension of a program mandated by Congress that is a massive legal target.
Right.
It's a binary action that courts can easily scrutinize and often enjoin immediately.
Yeah, that would be an immediate injunction.
Right. So by labeling this exorbitant cost as a monetary penalty inextricably linked to their enforcement authority, the administration attempted an end run around the legislative branch.
Ah, I
That
saw.
kept the program technically open on paper.
Avoiding the immediate legal vulnerability of an outright ban.
Exactly. But they deployed a $100,000 toll booth to achieve the exact same restrictive result.
And they dared the market to try and pay it. And like we said, only 85 entities did.
Yep.
Which brings us to today's ruling in Boston, where the administration's penalty framing ran headfirst into the judicial branch. Because in constitutional law, the exact definition of a word dictates the limits of power, doesn't it?
Oh, definitions are the entire battleground here.
Right.
U.S. District Judge Leo Sorokin issued the ruling striking down the fee, and his decision completely dismantled the administration's chosen definition.
What did he say?
Judge Sorokin analyzed the mechanics of the charge and concluded that it was not a penalty at all. He ruled that it was an unlawful tax.
An unlawful tax. That
Yeah.
pivot from penalty to tax, that is where the constitutional trap springs shut, isn't it?
Yes, exactly.
Because of the non-delegation doctrine and Article 1 of the Constitution, the moment a charge is classified as a tax, the executive branch loses all unilateral authority.
If we connect this to the bigger picture, the Constitution vests the power to levy taxes, the power of the purse, exclusively with Congress.
Right.
The legislative branch is the only body authorized to extract vast sums of money from citizens or corporations for the purpose of generating revenue or, heavily regulating behavior through financial burden.
Okay, so Congress taxes. But what about a penalty?
A penalty, conversely, is a tool the executive branch can sometimes utilize to enforce existing laws or punish specific unlawful infractions.
Ah, okay. So if it's a penalty, the president might have the authority to wield it. But if it's a tax, the president absolutely does not.
Exactly. And Judge Sorokin looked at the structure of this $100,000 charge and determined it did not function like a penalty for breaking a rule. Because, going back to our earlier point, applying for a visa is not an infraction.
You're just sitting in the driveway with your license.
Right. It functioned exactly like a tax designed to heavily regulate a behavior.
And the court examined the, what do they call it? The substance and application of the policy, right?
Yeah, substance and application. In legal analysis, this means peeling back the rhetoric and looking at how the mechanism actually operates in the real world.
Right.
Does it punish a specific bad act? Or does it apply a broad financial burden to an entire class of legal activity just to disincentivize it?
I actually want to read the judge's exact phrasing from the ruling here because it directly addresses that linguistic maneuvering.
I'll go for it.
He wrote, "Here, the substance and application of the $100,000 payment reveal that it is a tax regardless of what the payment is called."
Regardless of what the payment is called.
Yeah. They essentially slapped a label on a duck, call it a water eagle, and hoped the judge wouldn't notice it was waddling and quacking.
That's a great way to put it.
The judge is stating unequivocally that if it functions as a tax, the courts will treat it as a tax, no matter what creative terminology the executive branch puts on the memo.
And this goes to the very heart of the separation of powers. The courts are acting as the structural referee here. The executive branch holds immense power to administer immigration policies, direct border security, manage federal agencies, but the power to tax is purposefully kept out of the hands of a single executive.
So what is Judge Sorokin signaling to future administrations with this ruling?
He's signaling that the judiciary will look past the linguistic gymnastics. The functional reality of an action will always override the label an administration tries to attach to it.
It's a profound reality check for executive power. You cannot bypass the House and the Senate by pulling out a thesaurus.
Definitely not. This ruling aggressively protects the legislative branch's exclusive domain. I mean, imagine the precedent if a president could simply label any massive financial extraction a penalty just to avoid the friction of going to Congress.
The structural safeguards of the Constitution would just rapidly break down.
Completely. The executive could effectively rewrite domestic policy across any industry simply by pricing out the behaviors they dislike.
Which is exactly what happened here. We are looking at a scenario where an established federal program went from 85,000 standard visas to practically zero, entirely due to a unilaterally imposed financial blockade.
Yeah, practically zero.
But with Judge Sorokin's ruling, that specific financial blockade is dead. The $100,000 toll booth is being dismantled.
Right.
But, this entire saga really forces a hard look at how incredibly fragile these legal pathways are in practice.
They really are. They're heavily dependent on administrative mechanics. Because think about it, the statutory framework of the H-1B program, the actual law passed by Congress authorizing these visas, that remained completely untouched during this entire period.
That's true. Congress never held a vote to end the program.
No, they didn't.
Yet by simply manipulating an administrative lever, twisting a processing fee into an exorbitant regulatory tax, the executive branch almost entirely dismantled the functional reality of the program in a matter of months.
Yeah, it was incredibly fast.
From $5,000 to $100,000, resulting in only 85 applicants. It's a stark reminder of the immense power hidden in the seemingly boring day-to-day details of government administration.
And that's why the judicial branch serves as the critical backstop when those details are manipulated beyond their lawful scope.
Yeah.
The courts had to examine the undeniable economic reality, that chilling effect documented by the state attorneys general, and apply strict constitutional definitions to determine that this was a deliberate end run around the separation of powers.
So let's retrace the path of this deep dive. We started with a standard piece of administrative plumbing, right? The H-1B visa program, a pipeline designed to keep sectors like technology, medicine, and academia supplied with specialized global talent.
Right.
We saw that pipeline essentially clamp shut when the administration enacted a staggering price jump, weaponizing the fee structure to create a $100,000 barrier to entry.
And we observed the immediate paralysis of the program. dropping to a mere 85 applicants by mid-February, which really demonstrated the severe economic consequences of the policy, effectively freezing international recruitment for businesses across the country.
We then explored the legal showdown over definitions. The administration attempted to frame this massive charge as a monetary penalty, arguing the president had the authority to financially penalize the act of seeking entry.
Yeah, that was their main argument.
But ultimately, Judge Leo Sorokin brought the gavel down in Boston, piercing through the labeling. He ruled that the $100,000 charge was, in its substance and application, an unconstitutional tax disguised as a fee.
It really serves as a textbook example of the system of checks and balances functioning exactly as designed. The judiciary prevented one branch of government from assuming the exclusive powers of another through, creative definitions and administrative maneuvering.
And that is exactly why this ruling matters, even if you never plan to apply for an H-1B visa or hire someone who needs one. This case illustrates the vulnerability of our legal systems and immigration pathways when executive actions stretch definitions to their absolute breaking point.
Absolutely.
It shows how the courts act as the ultimate referee, ensuring that a tax is called a tax and that the power of the purse stays firmly where the Constitution placed it.
Because the foundation of our legal system relies on analyzing the substance of an action, not just accepting the labels assigned to it.
But it leaves us with a lingering, provocative thought to mull over. If the courts have firmly decided today that an executive administration cannot use exorbitant fees as a backdoor to restrict immigration, what other purely administrative levers might future presidents pull?
That's the big question.
If the toll booth strategy is struck down, what happens when an administration tries to change the speed limit or permanently close the on-ramps using obscure agency rules that don't technically require a vote from Congress? How far can the plumbing be altered before the pipes finally burst?
Well, the tug of war between executive ambition and judicial review is never truly over. The battle line just shifts to a new piece of administrative machinery.
A new technicality waiting to be tested. We want to warmly thank you for joining us on this deep dive. Keep looking closely at the news, keep digging into the details, and always keep questioning the information around you. Because sometimes the most boring administrative paperwork is actually the front line of a constitutional battle.
Well,
until next time.
For more breaking news and daily updates, follow MinuteWire. Like, share, and subscribe to stay informed.